Round two for Idaho's version of a Texas abortion law. Senate Bill 1309 says abortions would be illegal after 6 weeks, usually around the time a fetal heartbeat is detected, but before many women even know they're pregnant. It goes one step further to say extended family members can sue the doctor for performing that abortion. Dozens signed up to give public testimony today on both sides. Here's Katya Stepovic.
Life begins at conception, and life deserves legal protection at all stages. And so we are saying that right now, with this law, we're going to protect babies with beating hearts.
Blaine Consati, president of the Idaho Family Policy Center and author of Senate Bill 1309, says this bill finishes the work started last year by adding a private enforcement mechanism to Idaho heartbeat law that was signed by Governor Little in 2021. Consati's bill is modeled after Texas abortion law, Senate Bill 8, that limits abortions beyond 6 weeks, in some cases even earlier.
Every person should be able to make their own decisions about their health and their bodies, including abortion. No one's most personal medical decisions should be controlled by politicians, family members, or anyone else.
The bill states that if an abortion were performed, the father, grandparents of the unborn child, or sibling, aunt, or even uncle can sue the provider.
This bill also includes an extreme provision that allows the patient's family members to sue abortion providers with a promise of financial reward, even if they are not involved in the patient's care or the patient's life. This provision attempts to circumvent the rule of law by avoiding legal review, and it's clearly designed to have a chilling effect on abortion care by intimidating and harassing abortion providers.
If I have a one-night stand with a woman this weekend and she goes on to have an abortion, then for the next 4 years, I and my brother and my father each have legal standing to sue the doctor who performed the abortion. That is an absurd scenario because this is an absurd amendment.
Over 20 people gave public testimony regarding the bill, putting those in favor of it at a slight majority.
I believe that every single baby has the right to live, to succeed, and to pursue happiness. The millions of babies lost to abortion is a stain on our rich history, but you each have the power today to preserve the lives of future Idahoans.
Supporters claiming that the bill would prevent up to 800 abortions a year in Idaho.
Within about 22 days from conception, there is already a heart beating. And when abortion is performed, a heart that once was beating is forever stopped and a life is ended. Although our desire is to see abortions completely outlawed in Idaho, enacting SB 1309 would be a huge step in the right direction.
The bill includes exceptions for rape, incest, medical emergency, and for incidents where the baby suffered fetal demise.
I wholeheartedly believe that if I did not have access to an abortion or the choice to make that decision, I would have not been able to reach for my highest potential and would not have been where and who I am today.
Removing bodily autonomy and choice for women will only exacerbate the issue of intimate partner violence for many Idahoans. Idaho is among the loudest states in the country to champion freedom, and I encourage you all to keep that energy when it comes to opposing Senate Bill 1309.
And Brian, there was also concern about if this bill passes, the risk of women getting unsafe abortions or even traveling out of state to do so. The bill passed committee along party lines. It's now heads to the full Senate for debate.
A lot of concern there. Yes, you're right, Katya, and thank you very much. There's also the constitutional angle of this bill, something Senator Grant Burgoyne asked of the Idaho Attorney General's office. And according to the opinion of the office, as explained by Chief Deputy Attorney General Brian Kane, SB 1309 would likely be vulnerable to a lawsuit. Here's some of what he said. It would likely be found to violate recognized constitutional rights under the U.S. Supreme Court's current understanding of the U.S. Constitution. It could violate the Equal Protection Clause of the U.S. and the Idaho Constitutions by treating abortion providers differently than other medical providers who violate other state laws. It would also delegate enforcement to private citizens away from the executive branch, which is where it's supposed to be, a violation of separation of powers under Idaho Constitution, Article 4, Section 4. The statutory damages also may violate the U.S. Constitution's Due Process Clause. It could be determined a penalty of $20,000 would be disproportionate and unreasonable. Of course, some of these opinions could change should the U.S. Supreme Court overturn Roe v. Wade. There's also the question of standing when it comes to a lawsuit. There has to be an injured party. With SB 1309, the woman, the father, a grandparent, an aunt, an uncle, a sibling, anyone related to the unborn child could file a lawsuit. Chief Deputy Kane wrote, "It is difficult to see how a competent woman who consented to an abortion could suddenly have suffered an injury. And if she can't, how can anyone else? Bottom line, Idaho's Attorney General's office says they can see this bill being challenged in court before it is ever enforced and after. By the way, the state of Idaho has been challenged in court on 9 laws passed since 2004, and they've lost 8 of them, 1 of them still pending. On more than a handful of them, they were warned they would be a problem by the state Attorney General's office.